Good morning, everyone, and thank you for joining us today. We will be speaking about how to employ legal temporary labor utilizing the H-2B non-agricultural program. If any of you joined us last week, you'll notice that there are some similarities to the agricultural program, but the two programs are different in their own, with their own set of regulations. My name is Arnulfo Hinojosa. I'm Vice President for the Federation of Employers and Workers of America. FEWA is a national nonprofit association that consists of employers across the country that we help utilize in temporary guest worker programs, both H-2B and H-2A. So before I get started, I would like to begin with this disclaimer. The materials in this presentation are general in nature and are for informational purposes only. They are not offered for and do not constitute specific legal advice. Nothing provided within this presentation should be used as a substitute for the advice of your own independent counsel. I would also like to add that I personally am not an attorney. FEWA does have legal counsel on staff that works on behalf of FEWA membership. So let's begin. We'll be discussing today in general what is the H-2B program for anyone who has not participated before. We will also be going through many specifics about the regulations that were issued in April of 2015, known as the 2015 Interim Final Rule or 2015 IFR. In the time allotted in today's presentation, we cannot cover all the regulations, but I do want to cover the major points. Please feel free to ask questions throughout the presentation. We'll take those at the end. If you are currently utilizing the H-2B process and have a case-specific question, please follow up with me after the presentation. I'll be happy to discuss the specifics regarding your program. At the end of the presentation, my direct contact information will be available. So what is the H-2B program? There's an entire alphabet soup of visas ranging from investors to tourists to students. The H-2B visa category is categorized as a non-immigrant temporary work visa. This allows for any non-agricultural industry that has a temporary need for labor. It does not require a college education to be able to apply for the program. Any college-educated temporary visas are classified as H-1B. Some examples are some nurses, engineers, computer programmers, etc. Your temporary need could be any peak in your business that requires you to employ additional workers on top of your permanent staff. You can have a need for 1 or 100 additional temporary workers. The application process remains the same, and we'll talk about that process more in detail in a later slide. The H-2B program has a statutory limitation of 66,000 visas per fiscal year. There are no limitations on how many years you can participate and have the same workers returned to you each year. We will talk more about the current cap situation later. There are 4 different categories of temporary need that can apply for the H-2B program: seasonal, peak load, intermittent, and one-time occurrence. Many employers fall under the seasonal or peak load need. A seasonal need is based on a predictable pattern that reoccurs every year and only employs workers on a temporary basis. The examples here, snow removal and Christmas decor, are clearly tied to a season or based on the weather. Many of you likely fall under the peak load need. This means that you could do the job task you are requesting to fulfill year-round, but you are much busier during your peak season that is also tied to a predictable pattern and reoccurs every year. For example, if your work requires you to work outside and slows down during the winter with the cold and wet weather, then your business reflects a peak load need. You must have some permanent employees in the offered position year-round, and the temporary workers will supplement your permanent staff during your peak season. As you can see, I have listed landscapers under both seasonal and peak load need as an example. This is determined on what part of the country you're located in. Here in Texas, you would be considered peak load because you could do landscape maintenance year-round, just not as much as during the spring and summer. Some landscaping companies in the Northeast or in the mountains shut down completely for the winter as they cannot perform any landscaping duties for multiple months during the winter, which puts them into a seasonal need. So those are the basics of the program. I want to go over the different agencies involved in the paperwork process and their role. The State Workforce Agency, or could be referred to as SWA, will be involved in the testing the local labor market. What this means is that we have to prove that we attempted to hire U.S. domestic workers to fulfill the job positions you will have available during your seasonal need. The report must be submitted to the U.S. Department of Labor that details the results of your recruitment efforts. The USDOL will then determine the seasonal nature of your business and issue a certification for the amount of positions you did not fulfill with domestic workers. Once we receive a final determination from the USDOL, we must keep in mind that they are only an advisory to the U.S. Citizenship and Immigration Services. The USCIS will make a final decision based on the temporary nature of your business and the number of workers you are requesting. Once approved by the USCIS, they will notify the U.S. Department of State and the country of origin where your workers will be coming from. Each individual applying for a visa must go through a personal interview at the U.S. Department of State, consulate, or embassy in their home country before being issued a work visa. The process is a two-phase approval. Each employer has to prove their need to the government before being granted permission to employ foreign workers. Once approved, each worker has to go through an interview process before they are issued a visa to enter the country. I would like to take a quick look at the statistics issued by the USDOL for the fiscal year of 2016. As you can see, your industry is the largest industry that utilizes the program at 38%. The second largest industry is forest workers, and they are only at 8%. That 38% of landscaping and groundskeeping workers totals 44,981 positions certified in the fiscal year of 2016. Here are the top 10 states that utilize the program for all industries. Texas being number 1 at 15%, with Florida second at 7%, and the rest are between 3 to 5%. As you can see, the top 10 states are issued slightly over the half of the total of the certifications issued. For those who have not participated in the program before, I wanted to share the data on the set prevailing wages for the U.S. Department of Labor for the top 10 states, specifically for landscaping and groundskeeping workers for the fiscal year of 2016. As you can see, there's a pretty good range of wages for the same job in each state. Looking at Texas here, you can range anywhere from $10.13 to $14.20. This is because the U.S. Department of Labor determines the wage by the counties the workers will be working in, and all counties are different throughout the country and throughout each state. So now that we discussed the basics of the H-2B program and who the users are, I would like to cover the major requirements to participate. These are the topics that we'll be covering. The U.S. recruitment activities. So in regards to the timing of recruitment in relationship to your application, before there was an attestation model where the employer was saying that it had done things like recruitment or would do them. Now with the 2015 regulations, the employer is conducting the recruitment after receiving an acceptance from the Department of Labor along with specific instructions. Basically, we have to submit the specifics of your job to the Department of Labor. If they accept it, then they give us permission to advertise a position for U.S. recruitment. If there's anything they have a question on, they will issue a notice of deficiency which must be corrected or explained prior to get permission to advertise to local recruitment. One of the biggest changes is the recruitment period. Instead of a 10-day job order period with the state workforce agency, the job order will stay open until 21 days before your job opening. You will also be instructed to run 2 newspaper ads, one including a Sunday. You must offer the same position to former U.S. workers from the previous years that were laid off, not fired for cause. If you are not a union employer, you will also be required to post the job internally for 15 consecutive business days in 2 locations at the place of employment. Also, the Department of Labor will post your job on our national job registry, which means you could receive applicants from across the country. You must be willing to offer equal opportunity to all willing and able U.S. applicants. As noted, the required recruitment information is listed on the ETA 9142 Appendix B, which is a form signed by both the employer and, if represented by an agent or attorney, declaring under penalty of perjury that your application is true and accurate and you agree to all the requirements listed. These standards are pretty normal, no discrimination, but I would like to point out that all productivity standards must be presented up front in the job posting and in the advertisement. The no layoff provision is basically to protect the U.S. worker. The Department of Labor wants to be sure that you are not laying off U.S. workers to replace them with foreign workers. And if you have a lawful job-related reason to lay off early, such as lack of work or the end of a season, this is okay as long as the H-2B workers are laid off first before other U.S. workers in the same position. The job opportunity must be a full-time temporary position, and within the H-2B regulations, full-time is defined as 35 hours per week. And additionally, a work week is defined as regularly reoccurring period of 168 hours, excuse me. The definition of corresponding employment is corresponding workers as non-H-2B workers who perform either substantially the same work included in the job order or substantially the same work performed by the H-2B workers. Substantially the same work refers to either what is included in the job order or what action is actually performed by the H-2B workers. So it will be increasingly critical to make sure that those workers are not exceeding the scope of the application, or this could trigger corresponding employment for other workers doing the same thing that you had not anticipated being covered by the provisions and might not represent itself until a wage and hour investigation. You'll see the asterisk here, the FY 2016 bill currently does not allow the Department of Labor to enforce the corresponding employment section of the regulations. The current 2016 appropriations bill is set to expire on April 28th of 2017. We are yet to see if that's going to be continued through the end of the fiscal year of 2017 or not, but we'll find that out by the end of next week. But the Department of Labor does state that even though this is not enforceable currently through appropriations bill, that the Department of Labor, the rules are not vacated, but just not enforceable during this time period. So you need to keep that in mind. The employer must provide without charge or deposit all tools, supplies, equipment needed to perform the job. This can range anywhere from uniforms to steel-toe boots. Whatever is required to perform the job, you must provide to them at no charge. The 3/4 guarantee begins the first work date after the worker arrives at the place of employment or the advertised first date of need, whichever is later, and ends on the expiration date listed on the job order. Again, regarding the 3/4 guarantee, the FY 2016 appropriation bill does not allow funding to enforce it, the 3/4 guarantee, but DOL still states that the rule is not vacated from the regulations. The employer is liable under the H-2B for reasonable cost of inbound travel, daily subsistence expenses for all workers who complete 50% of the job order, as well as outbound travel, included daily subsistence for workers who work until the end of the job order or are dismissed early. In addition to the H-2B regulations, if the workers are entitled to federal minimum wage, then the FLSA, Fair Labor Standards Act, generally requires reimbursement of inbound cost in the first work week. The employer will have to disclose in the job order how we'll cover these costs. So if you're advancing the cost of transportation, if you'll be paying them directly or reimbursing them upon arrival, the Department of Labor wants to know up front in the job order. And whatever method is done for the H-2B workers will have to be the same way it's done for the U.S. workers as well. The employers are required to pay or reimburse within the first work week the full cost of the visa and visa-related expenses. Basically, this codifies the Department of Labor requirement that they are provided through their memos. These fees consist of a $190 U.S. visa consulate fee, and if they're traveling by land, a $7 U.S. dollar I-94 entry card fee. So prohibited fees for the employer. The employer and its agent or attorney and employees may not seek or receive payment, included but not limited to monetary payments, for any cost associated with a certification or employment, including attorney, agent fees, application costs, Department of Homeland Security petition fees, or recruitment fees. This is pretty straightforward. Basically, treat all workers in the same position the same regardless of national origin, as well as do not retaliate against an employee for any complaints. You will also be required to post these employee rights posters in your office, similar to the FLSA requirements, but specific to H-2B. They must be in the language understood by your workers. The U.S. Department of Labor currently has English and Spanish available. I know you cannot read them here, but they cover some of the points we have discussed today, like the employer's responsibility on wages, transportation, providing all tools, supplies, equipment required, etc. An employer may not place an H-2B worker in a job opportunity that is not certified on the application. They may not place an H-2B worker outside the area of intended employment on the certified application. These traditional concepts will take on a new importance when combined with the corresponding worker provision. If an employer inadvertently placed an H-2B worker outside of these areas listed, and there were U.S. workers that were employed in those areas, the corresponding worker provisions could be triggering covering those U.S. workers. The workers do not have authorization to work in a county not listed on the application or job duties either. The neighboring county you did not list because you do not have work in may have a higher prevailing wage, therefore could cause a problem during an audit scenario. You have an obligation to notify the U.S. Citizenship and Immigration Service and the Employment and Training Administration, which is a department of the Department of Labor, within 2 work days of any H-2B workers who separates before the end of the certified period of employment. You must also notify ETA within 2 work days of any corresponding worker who separates before the end of the period of employment. Once again, this is once the corresponding provision comes into play. If separation is due to voluntary abandonment by the worker and proper notification is made, the employer will not be responsible for return transportation, and you'll not be responsible for the 3/4 guarantee. If separation is due to dismissal for a cause, the employer is not liable for the 3/4 guarantee, but still liable for transportation expenses to return the worker to their country of origin. The employer will cooperate with any agent of the Secretary who is exercising or attempting to exercise the Department's authority pursuant to the H-2B program. The employer will retain all documents pertaining to the application, the recruitment-related documents, the payroll records, and related documents for 3 years and make them available to the Wage and Hour Department within 72 hours after request. For convenience, FEWA provides their members a flash drive with all the information we have submitted to the government on their behalf each year. ETA, the Employment Training Administration, may revoke labor certifications for a variety of reasons. Wage and Hour Department does have independent debarment authority, not only for employers, but also for any agents or attorneys. Debarment can be anywhere from 1 to 5 years and could extend to other visa categories as well. If you plan to use a foreign recruiter, you must provide the U.S. Department of Labor a copy of the contract with contact information of the recruiter and all their employees in the foreign country. And the contract must include a statement that prohibits the recruiter from collecting any type of compensation for job placement. You must pay the workers at least biweekly, and if offered at piece rate, you still must meet the hourly offered wage rate. Disclosure of the job order must be provided prior to processing in the language understood by the worker, which processing will occur in their home country prior to their interviews with the U.S. consulate or embassy. and any U.S. workers prior to their employment with you as well. Any payroll deductions not disclosed in the job order may not be deducted from their check. So an example, if you do a pay advancement and you did not disclose any of that in your job order, you're not allowed to do that. And of course, all deductions required by law are applicable in their paycheck. So after all that, so why do employers utilize the H-2B program? You can see it's a little overwhelming, lots of rules and regulations, and it's why the association FEWA exists to help you through that. But some of the basic benefits of the H-2B program is that you will have an abundant labor supply. Once you tap into a labor market in Mexico or any country, you'll have a referral list of workers eager to come work for you. All the workers will be legally documented, obtain a valid Social Security number, pay all taxes as a U.S. worker, and be able to obtain a driver's license if you need them to. The H-2B visa will be printed in the worker's passport with your company information. Therefore, they have authorization to only work for your company. If a worker leaves to work for another company, you have an obligation to notify the U.S. government of that departure. This is a rare scenario. The workers are very grateful at the opportunity to be able to enter the country legally and very loyal to their employers. We find a very high percentage of workers return to their employers, which will reduce in your training costs and allow for higher productivity. I covered most of these points in the previous slide, but to further show why the workers are grateful for the opportunity to enter the country legally is that an illegal guide can cost them around $2,000 US, depending on what country they are coming from. And this consists of risking their lives in the desert and run-ins with the drug cartel. Another great benefit for the worker is that the visas are issued with multiple entries. So if they have a family emergency while they're here working, their visa allows them to travel home and be with their family to return and then return to work at no additional cost, as well as they are not risking their lives attempting to enter the country illegally. So who is the prospective H-2B worker? Each worker applying for a visa must be able to prove their intent to enter the United States is not permanent. They can prove this by having financial or family ties to their home country. They do not need to have a lot of money, but something that is going to bring them home after their visa expires. The H-2B program is not meant to legalize undocumented workers currently living in the United States. Every applicant must apply for a visa in their home country, and if they have periods of stay in the United States undocumented, then they could be denied their visa. It is encouraged that every applicant be 100% honest during their application and interview process with the U.S. consulate. They will be submitting 10-digit electronic fingerprints, and the cross-check in the system is very up-to-date. So chances are the interviewing officer will know if you attempted to enter the country illegally 5 years ago and was deported. If there's an immigration violation on record and you were honest to the officer, they could submit a waiver on the worker's behalf, and eventually a visa could still be granted. Referrals are the best way to recruit potential H-2B workers from your existing staff. So the current cap situation, I have a comparison here for the 2016 year to the 2017. You can see there the big differences for the fiscal year 2016, we had a returning worker exemption. What this means is that anybody who had received a H-2B visa within the past 3 fiscal years was exempt from that 66,000 quota that we discussed earlier. You can see that the cap, the 66,000, is divided into 2 halves. The first half of the fiscal year beginning October 1st, the second half of the fiscal year beginning April 1st. In 2016, the cap wasn't met with the returning worker exemption until March 15th. This year, for the current fiscal year 2017, the first half without a returning worker exemption because it was expired, the cap was met 2 months earlier, over 2 months earlier on January 10th. Same scenario for the second half of the cap. With the returning worker exemption, it was not met until May 9th. This year, for the entire fiscal year for 2017, the entire cap was met on March 13th, 2017. So what are we doing to get a returning worker exemption put back in place? Right now, Congress must finalize a spending bill for the remainder of the fiscal year for 2017 by April 28th. This is our best opportunity for short-term cap relief while we're fighting for a long-term solution. We'll be heading to Washington, D.C. for next week with the H-2B Workforce Coalition for H-2B Advocacy Day to lobby for that fix through the appropriations bill. There's also been 2 bills introduced here, and with the presentation that you will be receiving, copies of the slide, you'll have links to these 2 bills. There's the House bill is Strengthen Employment and Seasonal Opportunities Now. This does allow for a returning worker exemption to be permanent, and as well as the Senate bill, the Save Our Small and Seasonal Business Act, also has a returning worker exemption in place. These are the citations and some of the things that we talked about throughout the presentation. And with that, I'll turn it over and answer any questions that may have came through.